Well, sometimes it may not be the case that the agent is selling something, which is different from what the customer is asking for. But sometimes you cannot compare the products, what is meant by best interest. Sometimes the premium may vary. So there's no yardstick to make an exact measurement. Well, in this case, the way you draft it is really problematic. I'm grateful to the insurance commissioner for your concern, but I think the legal advisor pointed out a very important point, and she has said this several times already. The focus here is that even though you draft the amendments in this manner and you refer to the considerations made by the court, you cannot avoid the issue. That is, the best interest of client is most important. The court may not even consider the codes or the guidelines. I'm just asking for clarity. I'm not trying to cause trouble for you. So I think we need to really work this out. All right, I will give an overall response. I think Mr. James Toh gave a very good example which touches exactly on this point. Mr. Toh was saying that the client indicated to the agent that he doesn't want to show a high level of investment risk. Then he doesn't want to show any risk arising from investment. Then you cannot sell him the product which is of an investment nature, but you can sell him something which is equivalent to a savings plan. If it is a savings plan, then the next question is which product is the best, because the fixed or variable rate of return offered by different insurance companies may vary. Perhaps I can use a simple example. Let's say even for example, travel insurance, is it the case that the company offering a cheaper premium would be in my best interest? That may not be so, because the scope of protection may also vary. But if the agent can only be the agent for certain products, then in the code we would say that if you're an agent, then you will consider the protection that the customer wants, and then you will find the best product that will suit his needs. If these are the products that the agent can sell, of course you cannot recommend the product of another company, because that would be against his code of conduct as an agent. He will need to tell the client that he represents these few insurance companies and sell the products of these companies. He can only recommend such products to the clients which best suits his needs. But it doesn't mean that these are the only products available in the market. But what he can do is to simply recommend such products. So in the code, we can clearly spell out the steps that the broker can do, subject to such constraints. And we can spell them out very clearly as to what the agent can do. Such detailed requirements in the law, it's difficult to be so detailed and to provide for these requirements in detail in the legislation. So, and it is exactly because we've taken this into consideration, and we believe we've just provided for the principle in the ordinance, and then the details are laid down in the guidelines. In Section 93, we stipulate clearly that according to this ordinance, in any legal proceeding, the court must accept the code of conduct as evidence, and when there are any issues arising from such legal proceedings, the court must consider whether or not the code, the provisions in the code of conduct has been complied with. Although we put down the term best interest of clients, but the scope is not so wide that it is subject to any interpretation, because it will be subject to the detailed requirements as laid down in the code of conduct. So we've looked at this together with the DFJ, and we believe that drafting it in this way is actually more favorable to the brokers and the agents, because in the code or the guideline we can spell out clearly what the agents or brokers need to do. So when we consult members regarding the code, then we can take on board the views of the industry, and it's much preferable than prescribing all these detailed requirements in the law, because it's simply not possible.
The IA explained, the DOJ says this is okay. By writing it like this, there can be a balance struck. Can the legal advisor advise whether this indeed is the case? Legal advisor, do you agree to the DOJ's view? Do you think this can reassure the industry because there is clarity in the law? Yes, Chairman. Number one, the administration stated in a paper that best interests would be construed in the code. That is all right, because the court will look at the code to see whether there is compliance with 891A. I agree with the administration. Number two, I'd like to confirm something, and this is also for members' knowledge. Under 891A as drafted, I said there could be a possible conflict between responsibility towards the principal and also the best interest for a policy holder. Maybe the administration can confirm this. 891A as drafted, if indeed that conflict ensues, then it seems that the present drafting will require the agent to act in the best interest of the policyholder first. It seems this is also the intent of the legislation. This is really what members should know, and this has been mentioned by Mr. Chan as well. There are brokers and agents, and the administration said there will be two sets of guidelines for the two categories of intermediaries, and the specific conditions may differ as a result. And if in 891A we only provide for best interest, now is that acceptable? This is for members' consideration. The drafting may not be ideal, but if in the code there is already separation, then members can consider whether it is acceptable to you. Are you clear? Yes. The first 2 points are clear, but not the third one. Your second point is that according to agency law, you have to be responsible to the insurer, but in the law now you change it to the best interest of the policyholder. We understand this, and for the sake of balance, the administration said there would be guidelines and there would not be imbalance, and you say this is all right. So actually we're not happy with the approach. However, if there are remedial measures, then it's all right. However, I fail to understand the third point. I don't know what you were talking about. Can you say again what you said as the third point? In 891A, there is no delineation. It only says an intermediary has to comply with 891A. But then, you also said, as stated in para 26, the court would have to make reference to this and that. And so the consequence is that the code will balance off the best interest provision. That is the objective, right? No, the status will never be the same because 891A is the law. But operationally, the code will be given a higher status. Is that right? When the court considers whether there is compliance with 891A, and if in the code the causes of action are provided for, then under 93(7), the court will have to make reference to the actual conditions in the code in order to decide whether 891A is complied with. This is how the law will operate, as explained by the administration many times. My question for members is, since there are two sets of rules, because there are two different categories of categories, because they would do different things, so do you still want to express the responsibilities by just using one term, best interest? Now I understand what you mean. You don't like the amendments done in a piecemeal manner. I agree with you, legal advisor. Now, should we make our own amendments? Administration, you still have time. As you know, there is a barrister representing the industry saying that you should not go for such a simple way to deal with such a complicated matter. Chairman, let me respond briefly. Whether this is the correct way to express it, if you look at other places and similar laws, if they also express the responsibilities between brokers and agents, they would only mention the principles of conduct, like those in Singapore and Australia. They only include the term best interest in the law. The rest will be provided for in the codes. Therefore, since we already have Section 93, there wouldn't be any confusion as to how the law will be enforced. We believe this expression would only include the principles of conduct. I don't think there is a reason for me to write the best interests of agents, the best interests of policyholders, etc., because that will be even more difficult. We believe the present construction is adequate because there will be a lot of other things that will be regulated.